Well, everybody, thank you for joining us today. My name is Michelle Jeffers, and I'm the Director of Business Development for Payment Vision. As you know, convenience fees provide our merchants with greatly reduced processing costs. However, the Fourth Circuit Court of Appeals recently pushed back on the case of Borrowers versus Carrington Mortgage, and this is allowing for a possible class action suit for violation of debt collection and consumer protection statutes by charging fees to make online and pay-by-phone payments. So with us today, we have Rob Mangarelli, as many of you know, is our VP of Sales, and he's going to be moderating the questions. So please use the chat box, or if you're shy and want to be anonymous, use the Q&A box with any questions, and Rob will be handling those throughout the show. Lori Nelson is our General Counsel and Chief Compliance Officer, and she will bring clarity to what this means and how it may affect your business if you collect or plan to collect fees. But before we get started, I'd like to turn this over to the founder and Chief Executive Officer of Payment Vision, Rob Poland.
Good morning, everybody. So since founding AutoScribe in 1989, and likewise our Payment Vision Alliance Commercial Data brands, we've always kept our focus on you, the customer. Our focus isn't on Wall Street, it's just our customers and doing the very best we can for them every day for the 5 industries that we provide payment supports that we specialize in. Today, as we celebrate our 33rd anniversary, that tradition continues today. That's why when our leadership team learned of the recent ruling from the Fourth Federal Circuit Court of Appeals on convenience fees, we wanted to bring it to your attention. And certainly, while it's not the news that we'd all like you to hear, we felt duty bound that you should know about it. So today you'll hear from Lori Nelson, AutoScribe's award-winning General Counsel and Chief Compliance Officer, on what the Fourth Circuit has ruled, as well as recent legislation in Maryland that we're keeping an eye on, and we'd certainly like to make you aware as well. Rob Mangarelli, in addition to moderating questions, will also be available afterwards in the event that after you discuss the potential effect internally, and perhaps seek any advice you have from your counsel if you want to make any adjustments. You'll be available to facilitate any adjustments to your account regarding convenience fees if that's what you choose to do. So thank you very much, and that, go ahead and turn it over to Lori.
Thank you, Rob. I do have to start with the legal disclaimer that yes, I am an attorney, but chances are I'm not even licensed in your state, nor do I represent you. I'm only licensed in Florida and in Tennessee. I represent AutoScribe, but as clients of AutoScribe, we wanted to give you this information to discuss with your representation. We're here for discussion points, but we cannot give legal advice, and this is not the intention of this webinar. So today we're going to talk about a case in the Fourth Circuit, and the Fourth Circuit, which includes Maryland, North Carolina, South Carolina, Virginia, and West Virginia. A pending Maryland bill, just as to keep our eyes on, and then options that you can consider. So going to the Court of Appeals opinion. If many of you guys know how the court system works, it starts with the district court, and this was filed in the federal district court. The borrowers did not like the outcome of that, so they filed the appeal. So when the panel of judges listened to the oral arguments in the appeal, they had to look at the case where Carrington is a mortgage servicer, just a mortgage servicer that services and collects mortgages. They're not, although not explicitly authorized by their loan documents, they gave borrowers a chance to make payments online and by phone for a $5 convenience fee. And they did offer a free mail-in option as specified in the initial mortgage documents. So based on that, the borrowers filed this class action challenging the convenience fees, alleging that it violated the Maryland version of the FDCPA law and the FDCPA itself, and said it attempted to enforce the right with the knowledge that the right did not exist. So when the appellate court looked at it, because the district court did dismiss all claims, they really looked at 3 different legal points. As you know, appellate courts are not there to rehear the trial. They're there to look and see if the judge made an error in judgment based on, allowing evidence in there, a matter of law, etc. So in this case, it was looking at the matters of law that was applied in the case. So the first item that the appellate court looked at was the term collector. Now, the federal appellate court did find Carrington to be a collector under the MCDCA. Now, I will have to state that under the FDCPA, the rationale is really this would be not really an argument that would pass, but because the Maryland law is broader than the FDCPA, it would apply in this case. So the mortgage servicer, although collecting, first party debt collector, looking at, clients that are current, in this case, this one was in default, and they did not specify that was the reason for classifying Carrington as such, but that could have been a reason for them to make this conclusion. But because the MDCPA is actually broader in Maryland, then Carrington was collecting a debt, and therefore it was a collector, regardless of if it was a servicer on first party. So again, this is far and wide and extends to any person attempting to collect a debt in Maryland from a Maryland resident. And this original debts, if Mazda gives a loan out directly, they start collecting debts. They're a debt collector under the broad interpretation of this Maryland Act. So that's huge, actually. Not really the topic that we're talking to today, but it's very huge because that actually covers a lot more than I think most people actually interpret it prior. So again, this is the FDCPA. So it does not apply to collectors who are collecting on their own debt unless in the process of collecting debt, the creditor uses a different name. So that's the FDCPA. In Carrington, they started the debt, they were servicing the debt. As in Maryland's, obviously was broader. But I do want to point out that you can look at other states within the 4th District and you may find the same issue. And I copied North Carolina's as an example. I didn't actually look further into the other states. But their definition of collector is any person engaging indirectly or indirectly in debt collection from a consumer, except those subject to their Article 70, Chapter 58 statutes, which it does encompass original creditors, assignees, regardless of whether the debt's in default. So I don't want anybody to start narrowing down this Fourth Circuit opinion saying it only applies to Maryland, because you would actually need to look at that individual state specific statute to see if they actually brought in that definition. So next, this is one of the more interesting points, the amounts. So the court held that this convenience fee qualified as an amount, that the FDCPA only prohibits fees that are incidental is not an argument that this appellate court agreed with. They concluded that this was a misreading of the statute and that the statute itself forbids any amounts unless expressly authorized by the mortgage agreement, and that the idea of incidental was simply an example, that they were not limited to that. The court specifically stated that Congress certainly did not want debt collectors to skirt this to logistic sophisticated, because then you would look at different collectors collecting different amounts. And if you had that issue, then you have borrowers paying an amount that they had no idea was coming, and it could be different across the board. So this, so the debt collectors from any amount, including interest, fee, or charge, expense, incidental principal obligation, unless such amount is expressly authorized in the agreement. Now, I will be honest and say I've been guilty, and my interpretation of this was incidental, and that's where my argument has always went. It's also where other circuits have actually pointed to in the past. You will find that in different opinions, so it's not an outrageous argument. This is the first court to actually write a written opinion on this and say, you know what, that's not the statutory purpose of that. Now, as I go to the third and really most important part of this too, and to really driving down convenience fees, if you guys have any questions, please submit them in the Q&A, because I know this is a lot of information. And when you look at legal opinions, it can be very confusing, figuring out what applies to what. So make sure that you put those Q&As, because we've got everybody's attention now and we'd love to address them. So the last item, permitted by law. You'll see this slideshow, and Michelle, if you want to give everybody else a copy after, after this webinar is concluded. But to give you a gist of this, the idea was that the Carrington said, you know what, the FDC doesn't permit us from going and having a subsequent contract with this borrower. We have a legal right to contract. So why are you limiting that to us? And the court came back and said no, because that still frustrates the FDCPA's intention, and therefore the FDCPA prohibits you from an additional contract for an additional fee. So before we would look at, here's this collection fee, it's not incidental to a debt. What it is a result of a secondary agreement with the borrower and the mortgage company or the payment processor to actually take this fee to give you this convenient method of payment. I will also mention in this case, they used speed pay. So they used a money transmitter where it took it directly out of the mortgager's hands entirely and actually collected the debt under their name. So this, I mean, it broadens out to every scenario you can think of, and them saying that you cannot do that if you're collecting on a debt, because what you're doing is adding fees that were not in the original term of the debt. So again, Carrington made a great argument, again, one I agree with, that said, you know what, this is permitted by law. You know, what are you doing here? You're taking away my rights. And they just completely went against it, and they said, you know what, you can't. And then the court went even broader and stated, referring back to the plaintiff's brief submitted in this appellate, is that it doesn't cost you anything, states the court, the court states that it actually should only cost you 50 cents versus $3 to do a check. And as we all know in this phone call, that is not the truth. I mean, to take a payment online, you're looking at PCI compliance costs, web page costs, etc. A lot more that obviously wasn't identified by the plaintiff in their brief, nor was it identified in the defendant in their brief, likely to the fact that they wouldn't think a court would actually look into the cost analysis of the process, but they did in this case, and that's where they really drilled down this idea that this is absolutely against the terms of the FDCPA, that you're just trying to collect more fees. And they did not specify in this case if there was any revenue share. Obviously, no revenue share could have been more of a defense, but we didn't actually hear that argued in this case. So that's the gist of where the appellate court decision went. To give you an idea, so what they're saying is, you know what, you're a mortgager, you're a collector, because you're collecting on a debt. I don't care if you actually were the original creditor, and you cannot charge a convenience fee because it is not specifically in the state law or agreed to in the original agreement for that. There's no other way you can charge any fee for any type of service, any way related to that debt in any manner. So if it's for any type of service related to that payment, you are not allowed to collect it unless you have it in that original terms. So it's a different opinion that we've seen in any circuit. And it was obviously written, which many appellate courts do. They document these opinions that have a new idea of law in them. This is new precedent in this circuit. This is telling people that unless you have it in the original terms of the debt, or in the case of Maryland, they actually update their state law to allow it specifically, you can't charge it. And as we continue to look at Maryland, whereas we know that they're pretty liberal in their application today of the FDCPA, they actually have a state bill pending that is even more that is very specific to convenience fees and borrowers. And they state that you cannot charge a fee for check or cash or money order. And then second to that, also specifies exactly what this court's saying, that you can only if it's authorized in the agreement. Disclosed again in the time of the payment, but they do even further that by saying it can't at any time exceed the actual cost of the third party to process. It has to be a straight line to the third party, no revenue taken on by the debt collector. So that was a lot. And from that, I'm going to go over this briefly, but again, Michelle's going to give you this deck where you have all of this information, because when somebody comes to me and says, what do I do? Where should I go from here? I talked to my attorney. My attorney's telling me that at this point, there's a risk that more class actions are going to come from this, especially in the Fourth Circuit, where this is present right now, that this case law, that this appellate court decision has created can be applied to future class actions. What do I do? So if you were to take the decision not to actually charge a fee to clients in the Fourth District and taking that approach, what could I do to actually, where does that put me? And there are programs out there to significantly reduce your interchange if all of a sudden now you're actually taking that in as a cost. And one of them being the debt repayment program. And I like to always point this out because it's huge. It's been around since 2008, and I'm always flabbergasted by how many people do not take advantage of this. So it goes and it specifies the financial institutions, non-financial institutions are the only two merchants that can take advantage of this. And as of 2018, they updated that to reduce it even further than it was previously. And if you have no convenience fee charge, your interchange for all except the regulated, which is already 0.5, is 0.65 plus 15 cents. Huge. I mean, it's a huge reduction when you're looking at sometimes 2%. If you do have a convenience fee, so let's say you register for this and you decide to continue to charge convenience fees in for clients outside of the fourth district, you can still save. There's a $2 cap on this one. Same interchange, you got a 65-cent cap on the first one, $2 cap. So significant. And so you could take advantage of these programs and actually have it to where, you know, if you still want to charge convenience fees, you're still capping everybody at $2. And that it's, again, significant. And it's kind of one of those things I like to remind everybody that if you're collecting on debt, you should be taking debit only. However, you know, anyways, that's Visa rules. And because of, you know, you want to be in compliance. So this is really just getting you in compliance. And this is, so I also have on here MasterCard's notes on it. They have the same type of program. Theirs are not as significant, but you know, it's going to reduce it. They do have they mentioned that the maximum convenience fee charge to a cardholder should be $4.95. When you're capping out at $2.95 and $2, doesn't seem unreasonable. And I kind of put in the details about actually how you do that. But this is where I said, if you collect on Visa cards at any point, you cannot accept a payment of the debt unless you are a financial institution, non-financial institution, and you're only collecting with debit cards. But there's an example savings in this deck as well that you can go through where somebody took the time to take a statement and actually apply the reduced interchange. So again, like I said, I just went over a lot, and I really intended for this to be more of a Q&A, so I could get ideas and questions that you guys actually have from this. I've kind of lived in it for the last couple of days, so it makes perfect sense to me, but I know it's a lot for everybody else. So Rob, if you want to.
Sure. So we had someone very excited and sent some questions pre-webinar. And the first question is, does this mean that the mortgage company will have to return the fees collected to date, going back? If so, going back how far?
Again, I cannot give legal advisement to that. I think it's kind of depending on, we don't know too how this class action is going to settle. This has actually been reprimanded back to the district court, and this district court is going to apply this reason of law to that portion of the lawsuit. It's like a smaller hearing, and they'll go through and decide if the class action can continue. The damages on that, I don't know if they'll look at going back or if it'll be from a time period. If you find this to be, if you're collecting the fourth district and you read this to say, you know what, I don't want to take this chance that could be sued, then I would advise to look at maybe at least taking a good faith attempt and stopping today. I don't know about backtracking as much. There is no defined date on that. Today, this just became present law. The law just went into effect as case law when this opinion was written.
Okay, another question from the same individual. Does the Fourth Circuit's ruling extend to areas outside the Fourth Circuit, specifically Tennessee and Kentucky?
Are they president in that state? Presidents in that state mean, does that court have to apply that case law? No. However, it is highly, you know, influential to other courts. When you see an appellate court written decision, there are appellate court written decisions in other cases. I'd have to look in that specific circuit and see what was there, what you'd actually defend. There's some really good opinions for convenience fees in other circuits. So, I mean, it's one of those that it will just depend on what you have to actually argue against it. If you have an opinion in that fourth circuit, in that other circuit, this Fourth Circuit is not going to trump that. You know, that's still the law in those circuits.
Okay, thank you. Another good question. Are they determining the ban on collecting fees based on the geography of where the customer resides and or where the company headquarters are located?
That is a very good question, and one we get a whole lot, but this is actually to protect the residents within that circuit. So it'll be where you're at, the borrowers are located.
This is a little bit of a hypothetical. Will this appeal be appealed?
It could be. So, this isn't a federal appellate court. They have up to 90 days under the Supreme Court Rule 13 to actually submit a writ to actually have the Supreme Court review that case. But, the Supreme Court looks at about 100 to 150 cases, whereas you're looking at about 7,000 that are submitted. So it depends. Is there a chance? Yeah, there's a chance. I am telling you there's a chance, but I don't know. And they have not actually submitted that notice or have actually given any reason for us to think they're appealing it at this point. But again, they have 90 days. They could actually submit that on day 90.
And the Supreme Court may or may not hear it.
Correct.
But they
you're rolling the
override it.
dice getting that. The one good thing this has on its favor of looking at a potential Supreme Court taking interest into it is we do have contradictory opinions within the circuit.
Mhm.
And this is a big, and at least maybe we're involved in this industry so much. I was like, this is a big deal. This could affect a lot of people and a lot of companies, that it would be great to get a law that applies nationwide versus having to look circuit by circuit.
Okay. Two more by the same individual. Is there, per the Fourth Circuit, a way to legally collect a convenience fee going forward?
There is, and that's kind of what they define, and it's in this presentation. Kind of want to ever go back to it. Is that unless it's specifically authorized by state law, which we know Maryland is not, it has to be in the original agreement. Period.
Okay. One more before we get back into the presentation. Is the ruling broad enough to include indirect lenders, or is it specific to the mortgage industry?
Oh, it's broad enough. I mean, it's broad enough to cover mortgagers. So it already covered you guys based on just like looking at the different matters. Anybody that's a third party. This covers anybody taking a payment on a debt, regardless if you're the original creditor.
Okay. We have 7 others. You want to take those at the end? Or-
That really was the end.
Oh, that was,
But
okay,
yeah,
okay.
like I said, it's a lot of information and I try to touch on things, but I really want your questions because I want to know what you want to know more about. And like I said, really you have to kind of decide on your end what you want to do with this information and kind of advise with your counsel on that.
Okay, good. So we have 8 more questions so far. Will Payment Vision be able to block convenient fees by state?
Yes. So if you are a client of Payment Vision, which if you're not, we want you become one. We do have the ability within our technology to actually segregate those in those
By
states.
state, yeah. Can you please share a copy of the 4th District case?
Okay, I'll send that to Michelle. And Michelle, if you distribute this PowerPoint, you can also distribute a copy of that with it as well.
Okay. If we add the convenience fee language in our original paperwork with the original debt agreement, can we charge our convenience fee?
Yes, and please do that. That's the best case you can be in. And you can actually, looking at, and again, you have to advise with counsel, if you have the client agree that a convenience fee will be charged, I don't know, you have to even specify, you don't want to specify that amount because that can change from time to time or channel. They just have to agree. You could do something not to exceed in case somebody tries to identify that as too broad. But yes, absolutely. If you can get that in the original terms of the debt, you need to be doing that.
Good. Is it possible to have a change in terms made to include these fees, or does it have to be in the original agreement?
The court kind of touched on that, saying that it's, when you look at the law to contract, I guess this would actually, again, we're looking at opinions now. So my interpretation of how they review that, if you were the mortgager or somebody had the original debt and not the debt collector, if you went through and amended something, you have a better argument than if you were a debt collector. Because a debt collector, that borrower had no choice where to go.
Mhm.
But on that same note, that borrower is still going to argue, I never agreed to this, or I would never have went with that mortgager in the first place. So it's a risky idea, even that. I mean, there's risk to consider on either end when you look at that. It's better than not having an amendment to the agreement.
Okay. Here's a question specific to the state of Tennessee. If a class action is brought in my state, Tennessee, how long do you think it would take to work its way through the courts?
Oh, wow. I mean, that's class actions are not something that you see easily. And again, I have to go back and look at the circuit opinion today that covers Tennessee and tell you what was held before. And I could look that up and see if I have any notes on that, because again, this is 4th District opinion. And while I said it's very influential on any court that sees it, if your circuit has ruled differently, that appellate court in your circuit is what the court will go by.
And Lori, which states comprise the Fourth Circuit?
The Fourth Circuit,
Yes.
that's Maryland, North Carolina, South Carolina, Virginia, and West Virginia.
Mhm. Do you think every payment method needs to be in the contract, i.e. MoneyGram, Western Union, Pay Near Me, the competitor, credit card processing fees, and free ways to pay, etc.?
I believe that you don't have to be that specific. Obviously, the more specific you can be and the more information that they agree to, the better. But if you made it clear to them that the prime, almost when we go back to the argument itself that we've always looked at for convenience fees, per Visa law, if you pay what we consider the primary method and list that in the agreement, this will always be free. But please note that, agreeing to this debt, you are also acknowledging and agreeing to the fact that we can charge a convenience fee for other means of payment.
When referencing Pay Near Me in the last question, we, Payment Vision, also offer walk-in cash payment options across the US. So do you think every method of payment needs to be in the original contract, i.e. MoneyGram, credit card processing, same thing? Yeah,
Just do
it's the
that.
same question, just asked differently by another company.
Yeah, like I said, I mean, obviously always the case when you're looking at defending yourself, the more specific, the less room for interpretation of somebody saying, well, that's not how I thought, that's not what I read. I mean, but do you have to be that way? In my opinion, no.
Can a convenience fee be charged on the collection of Maryland state tax debt by a third-party collection agency?
If you were to review this opinion the same manner I review it, you're collecting a debt. There is no exclusion in the Maryland law for a tax agency debt collecting. So it's covering everybody. It's very broad that way.
We have customers that use American Express cards to make auto loan payments for their points. Is this an issue?
Well, Amex, just so you know, does not allow their cards to be used for the repayment of debt. They're very specific on that. I mean, that's really with the cardholder and the borrower for that. If you're charging them a fee, you're looking at the same situation you're in here. It doesn't matter what card or why you're charging that fee. What this case is saying is that within this group of facts, or within the state of Maryland under Maryland law and this, you cannot charge a fee unless it's in that original agreement.
For indirect auto lenders, understanding that this could expand beyond the states within the Fourth Circuit domain, would this apply to the borrower's current state of residence or the originating dealer state?
It depends. So you're looking at if a court said, when you made this agreement, they lived here, and that's where this is the law that applied. And then you actually started collecting the fee that's already there, right? You've already been covered. But let's just say they lived in Maryland, you had that, you didn't collect the fee until they were outside of that state. You would have the argument that you didn't violate Maryland law because you didn't charge in Maryland a fee. It's kind of, you have to go down those different paths. It'll be harder, all those cases, and there's all sorts of situations. You just kind of have to decide where you want it to go. But if you are making an agreement with a Maryland borrower, you could not charge that fee while they live in Maryland.
Okay. I'll read the exact whole message. Hi, Lori. Hope you're doing well.
Yeah.
Looks like this does not touch on pure pass-through arrangements with no revenue share. Wondering if this is still safe and if still allowable on the PV Payment Vision platform while we analyze options in the fourth.
Yeah, no, like I said, you need to review this and kind of look at it. They were not specific to that. And then we would hope, again, let's say I wanted to defend that position. I would actually look at the court's interpretation of these fees and say, why are you telling me it only charged me for 50 cents? Like I'm charged this, look here, I don't receive any part of this. This is what it costs me to actually collect. Yes, there's an argument to be made that actually takes this line of facts and argue why it doesn't apply to your case.
Good. Here's a good question. Can we charge a convenience fee for a credit card payment?
I mean, you can always, the convenience fees are allowed under Visa and MasterCard. You can always do that. One thing you're looking at convenience fees, and what we've always been looking at, because we figured out really quick how to get into compliance with Visa and MasterCard, is can you do that under the FDCPA? Well, our argument was always not incidental to a debt. It's a separate agreement. You're doing this. So this is the first case that said you know what, I don't care, incidental doesn't matter, and then Maryland is even broader. So the answer to that is yes, and always yes and no, depending on where you're at, what you're doing.
Okay. Do you think this 4th District Court opinion would sway the 11th Circuit?
Again, I have to review what the other circuits specifically have already ruled on it. And then from that, if they haven't ruled on the specific issue, you're going to have a judge having to consider not just the 4th Circuit, but someone's also going to bring in the 6th Circuit, which said something good about it, you know, or the 8th Circuit. So unless that specific circuit has ruled on this, is there an absolute fact? I mean, is it absolute that they're going to follow it? No. Could they? Yes.
Okay, a few more questions. Currently, we are accepting payments with credit cards. Can we continue to accept credit cards if our plan of action is to add convenience fee language to the original debt agreement?
Absolutely. I mean, again, as far as what you're doing today in the between then and there, that's your risk factor that you kind of have to decide on if you continue to collect those that do not have it in the original terms of the agreement. So that's really, you know, you kind of have to decide how you want to look at it. Do you want to make an argument based on that one piece that they included within their opinion of cost? Do you want to do that? This is a risk factor and analysis that you guys can have to do on your end with your counsel.
Okay. What is the process to discuss any changes to our charges with Payment Vision? We will reach out to you directly.
Yeah, send an inquiry to Rob if you want to make changes to that. And that is all the questions right now. Do we want to leave it open for a minute or two for any more to kind of come right in? Looks like
Yeah.
one more just popped up.
I'm going to email Michelle the copy of the opinion now.
Yeah. One thing I wanted to point out is that that Payment Vision provides services or through convenience fee modeling as well as Interchange Plus. And we've always been very transparent about our fee structures. The numbers that Lori shared with you earlier is essentially the interchange cost. It does not include our costs on top of that. So I just want to make sure you guys know that if you make any changes to service, we're very competitive. Price she actually shared is the basis for performance.
Okay, one more question came in. Are we correct that financial institutions are not allowed to charge fees when collecting payments on consumer credit cards, no matter the source?
No, I don't, that's not a correct statement. Like I said, we've always been an advocate of convenience fees. We're a business. We understand businesses and we want to make it make sense to people. I mean, if there's a way that you can not have to take on that cost of it, we try to figure out ways to do that rather than having to impose our cost of keeping the PCI, doing everything of that nature. Passing it on is completely viable under the Visa rules. Did they say credit card? Yes, credit cards.
Credit cards.
So Visa rules, however, is specific that you should not be taking credit cards for debt. And that's always been the rule. This is not new. This is older than day. This has always been the case. We have not seen, obviously, Visa take a proactive approach in trying to enforce this, really. I mean, you will find, we've all heard about those. We all know about the one bank where a payment processor had to terminate a huge portfolio because they said, wait a second, you know, these people are not collecting, they're collecting credit cards, you know, when you're doing debt. So you have risks of that nature. But
take a debit card, but not a credit card for their daily debt.
And one more question. How about a fee, a convenience fee on a payment plan on the collection of a judgment for medical bills?
I would look at that judgment as the agreement, and then I'd have that judgment specify that a convenience fee may be charged if you can. As far as that goes, I mean, you still have a debt, and under Maryland, you know, you're looking at that would be covered under that. If you're a debt collector for that judgment, it would be covered under that. So that judgment is there by your agreement.
Great. Any more questions?
As we're going through this, I'm just wondering if it might be valuable if we posted an internal discussion board or some questions to see.
Yeah, and Michelle, go ahead and give them my email too. People can email me directly, copy Rob on it, so we can have some dialogue going through with this. Like I said, I know it's a lot, and trust me, we don't want to have to say things like this. We are a huge advocate of convenience fees. This is not an opinion that I necessarily quote unquote agree with, nor happy to see. To be honest, again, just opinion, I feel like this court went very broad and liberal in its approach to defining a law that has been in place for many of years. And to have an appellate court discuss fees and the cost of things was very surprising to me.
Yeah. I mean, they're not the ones that have to shoulder these costs.
Correct. I mean, we're looking at the law. We're not looking at what that actually means as far as a revenue standpoint. If they specifically said, you know, they made revenue on this, so it's bad, that's another story. But to come out and take the plaintiff's arguments of what it actually cost somebody, which they did get it from a source, I think it was a financial planning source of information. The plaintiff put that in their brief, but that doesn't, what did that actually consider? You know, how's it cost $3 to process a check and 50 cents? Are they looking at how much it costs for your employee overhead? You know, it's not the system that does it, that costs thousands, you know, how much more to do it, so.
Okay, any more questions?
And hi, Ari, hope you're doing well as well.
Thank you all for your time today. We really appreciate it. We appreciate your business and support over the years. Have a really nice day. Be sure to reach us with questions. What we provided was not legal advice, but it's a basis for you to have discussion internally and to seek the advice you need to make the right decisions for your firm.
We just wanted to get this on your radar. Thank you so much
Thank
for your
you.
time, and
Thank you. Have a good day.
soon.
Bye-bye.
Thank you, everybody.
Thanks.